Vusimuzi Cat Matlala is once again at the centre of South Africa's anti-corruption spotlight. He is expected to stand trial on Monday for serious charges including attempted murder, money laundering and fraud after agreeing to testify before the Madlanga Commission and entering into a plea agreement with the state over the controversial SAPS tender corruption case. The legal landscape has shifted dramatically. The court rejected that original plea agreement and proposed a harsher sentence, prompting Matlala to abandon that deal altogether. Let's chat a bit about this now with Tumelo Vana, an attorney at Vana and Tshabalala attorneys. Tumelo, thank you very much for your time. We do appreciate it. I mean, with that plea agreement, of course, off the table now, we know that the NPA or IDAC cannot use any of what was contained in this controversial affidavit that Cat Matlala is believed to have deposed, which indicates or seems to suggest that there are higher profile police officers that were allegedly involved in this corrupt deal. Talk to us a bit about that and how investigators essentially have to start from scratch in terms of their investigations.
Good morning, ma'am, and good morning to all the listeners. Now, remember, for trial to begin, it means that the investigations are or should be concluded. Trial cannot proceed without the investigations being concluded. Now, before a trial can begin, the accused and their respective legal representative have to be furnished with everything that the state has to use against them. So it means at this stage, the investigations are concluded. That's why now they are proceeding to trial.
I want to speak specifically about what we saw at the Madlanga Commission of Inquiry. There were expectations that there was a postponement that was going to be asked for. Let's talk about the basis for which his legal representative had asked for the postponement, speaking specifically about a risk to Matlala's prospects of or an infringement of his rights, for example, if he was to continue with his testimony without that trial having begun.
Okay, what the legal representative of Vusimuzi Cat Matlala was actually worried or concerned about, it was the issue of self-incrimination in proceeding with the commission, and ended up or might end up using stuff that might be used against him on the pending criminal matter against him. So for her to request a postponement, it was for them to be sure, like, the information that the commission want is not the information that will be used for the trial that is about to begin, whereby Vusimuzi avoiding incriminating himself before that, which I believe is a fair request because of the law protects people against the self-incrimination, especially in such a commission. If he exposes some things, then the NPA decides to use whatever information he would have given to the commission against him. So what she was fighting for, what the legal representative was fighting against, is to avoid, or the client avoiding issues of self-incrimination in the commission.
And I mean, you know, from what we've heard inside court in the Medicare contract court case that has been underway. The allegation, of course, is that Cat Matlala was the alleged mastermind in this particular rogue contract, and there had been, I guess, behind the scenes. This is what we also asked the NPA, whether they believed that there'd been some kind of behind the scenes negotiations, because it seemed at some point that Vusimuzi Cat Matlala was willing to take this deal. This plea deal. But then again, behind the scenes, what was also revealed in open court was this affidavit, which is believed to contain very high-profile names who the state, I recall, at the time when they indicated why they were accepting this deal with the defense or taking it, was because of the caliber of names and the caliber of information that that he was actually providing to the state in terms of other individuals that need to be investigated. How much of a setback is this in terms of the state's investigations? Because now, obviously, they have to start doing their own work. And if we look at what the state indicated at the time, was that they wouldn't have been able to secure any of those people if it was not for the information and corroborative evidence which they suggested Matlala had given them. Hence, they were wanting to take that 8-year deal that the defense had also agreed to.
I understand that initially the state and Vusimuzi Cat Matlala and his legal team, they've entered into an agreement in terms of Section 105A of the Criminal Procedure Act, wherein if parties agree on a sentence and a plea, then they can try to deviate from the prescribed minimum sentence. But then the presiding officer or the court has a final say in that. I mean, they are not compelled to agree with the sentencing that the state and the defense might agree on. So now it puts the state back now that now the onus now again rest on them in proving the buffet allegations against Vusimuzi Cat Matlala and his co-accused. So initially what I believe wanted to happen, or from what exists to the public domain, was that if they were to enter into that agreement, he was probably going to convert into a state witness, which would actually make the case state much easier to prove, since, well, they would have had a witness who was actually a participant in the alleged criminal conduct that the senior members of the South African Police Services are allegedly or have been allegedly involved in. So it would have made the things quite easy ahead. They have reached that agreement for the state actually in that. But now, since the presiding officer felt like, no, that sentence that they have agreed on is too lenient for their allegations that the accused is facing. So at the end of the day, remember now, when it comes to plea deals, the court is not involved. It's an agreement between the state and the defense. And the court does not have to agree on that. It's independent. So now in evaluating those or that agreement, then the court reached the conclusion that that sentence will be too lenient for the offense that the Vusimuzi Cat Matlala is currently, or the charges that he's currently facing.
I mean, what can we expect? I know that sometime in July, the date actually just slips my mind, he has got to depose of an affidavit to the commission, and obviously he will now be appearing before the commission at a later stage. I mean, what are we likely to expect from Vusimuzi Cat Matlala? I mean, the man who's being perceived to be the mastermind behind all of this.
Well, remember, I also cannot really answer that, because of what I have is what the public has. What the state has not yet been fully disclosed to the public. So what to expect on the commission, I really cannot or do not have an answer to that.
Tumelo, thank you very much indeed. I think we're all just speculating at this particular point in terms of whether he will spill the beans or not, given the fact that, he had that plea deal that he'd struck with the state. He was willing to give the names of other individuals forward. That, of course, has collapsed. We don't know if he will use the same approach as he goes to the Madlanga Commission of Inquiry. We'll all have to wait and see. Tumelo Vana, thank you very much indeed. We do appreciate your time. He's an attorney at Vana and Tshabalala Attorneys Incorporated. Thanks for joining us.